The election certification process has gotten a lot of attention since the 2020 election and the January 6th insurrection. In 2022, Congress passed the bipartisan Electoral Count Reform Act, or the ECRA, in an attempt to reform and modernize the electoral process. So what's different? The first change has to do with electors, the people who cast their votes for president and vice president at the meeting of the Electoral College. In the past, a state's legislature could appoint electors after voters had cast their ballots by declaring a so-called failed election. But the ECRA says that each state's electors must be appointed pursuant to the rules in place on Election Day, meaning the legislature cannot change electors after the vote. The second change is about certification at the state level. It defines the deadline for election certification by each state to be 6 days prior to the meeting of the Electoral College. This is to create time for any potential litigation. It also defines the governor of each state as the default official tasked with such certification. The third change is about legal challenges. It creates an expedited federal judicial process for any legal challenges by a candidate to a state certification of electors, basically to make sure everything is resolved before the Electoral College meets. The last two changes apply to January 6th, the day Congress counts the electoral votes and finalizes the election of the president. The ECRA states the sitting vice president's role in the process is purely ceremonial. It also raises the threshold for congressional objections to electoral votes to 1/5 of each chamber of Congress. Before, it was just one senator and one representative. This helps reduce the risk of bad faith objections. Bottom line, there's a lot happening between Election Day and January 6th. The ECRA is Congress trying to make things more clear and concise.